So we are basically, in some ways, offering a path to the Menendez brothers. And here's what the pathway looks like. If the Menendez brothers at some point, unequivocally, sincerely, and fully accept complete responsibility for all their criminal actions, acknowledge that the self-defense defense was phony, and their parents weren't going to kill them the night of August 20th when they murdered them in cold blood. Acknowledge that they suborned or attempted to suborn perjury in all the various ways I have outlaid. If they go ahead and finally come clean with the court, with the public, with the DA's office, with their own family members, and acknowledge all these lies, and then can be said to have fully and completely accepted responsibility for their actions. In the future, the court can weigh these new insights into making a determination as to whether they now qualify for rehabilitation and resentencing. They didn't mention self-defense. What they said about the father, what Erik said, is that he was a controlling, dominating force, and that is the reason that he was killed. The district attorney's office, if it is presented with these new insights, unequivocal, sincere acknowledgments of all the lies they have told for the past over 30 years, we too, in the district attorney's office, will reconsider whether or not we would want to go forward with a resentencing motion. But for now, while the Menendez brothers persist in telling these lies for the last over 30 years about their self-defense defense, and persist in insisting that they did not suborn any perjury or attempt to suborn perjury, then they do not meet the standards for resentencing. Resentencing hearing on that motion. However, we are asking the court to withdraw the... So those hearings, whether they occur on March 20th or 21st or at some point later, first it's up to the court on what the court ultimately wants to do. The court is receiving our response today. We anticipate the court may keep the March 20th and 21st dates to deal with our response. Again, part of our response is to go forward with the court's initiated motion for resentencing, and part of our response is a request to withdraw the DA's motion in this regard. The court might have the hearing then on that issue, and then if in fact it decides to go forward with the full resentencing, set a hearing in the future. The key hallmarks of resentencing is, do the defendants pose an unreasonable risk? Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions. At that point, Sirhan, who was the assassin of Senator Robert F. Kennedy in the Ambassador Hotel. So, in looking at then whether or not the Menendezes have exhibited the full insight and complete responsibility for their crimes, they have not. Because, and we outline this in 20 different lies that they have told, which is an attachment to our submission. They have told 20 different lies. They've actually admitted to 4 of them, but 16 lies remain unacknowledged. The mother. What doesn't happen in any of the tape conversations with Dr. Oziel, and remember, I understand that the Menendez family members want, the ones that are supporting this, want the Menendezes out today. They could go to the governor if they wanted to actually achieve that, literally go to the Governor Newsom today, and he could commute their sentences and release them today. I, on the other hand, am bound by the facts and the law as it pertains to an analysis of whether or not resentencing is appropriate.
If they get out, what does that say about the current